This session is going to be on bylaws and dispute resolution. Okay, once again, I'm Kelly Whitfield, Principal Policy Advisor from Landgate, aiming again for this to be a 30-minute session with 20 minutes for questions. It's bylaws and dispute resolution. I'll be looking at some of the challenges under the current Act, and what's changing as part of the strata reforms, and how to find out more and have your say. Okay, I think everybody, all of these faces were in the earlier session, so I'll just lightly skip through this. The Strata Titles Act 1985, very important act, especially it's one that actually affects people who live in strata. So people who live in strata schemes, it's this act that tells you how to manage the act and the things that need to be done. It's a bit of an unusual act in that sense that it's relied upon by such a large number of essentially lay people who might not necessarily have that much experience in reading legislation. One thing I can tell you is that the current act that hasn't yet been amended, it's a really horrible act to read. It's complex, long, it's been amended over time. The amendments are sort of stuffed in higgledy-piggledy in different areas. It doesn't have general principles. It's really specific. The structure's all over the place. It was written at a time when writing things in legalese was, it was the fad. So it's actually a really difficult act to read, and I'm going to be very happy to see the back of it. So late last year, it was amended by the strata reforms. It's a really, really comprehensive suite of reforms that's coming in. And when they are actually proclaimed, the Strata Titles Amendment Act will be nearly completely different to read. It's going to be really well ordered and organised. It's far more plain English, far easier to understand. And actually, I'm going to be quite proud of it when it finally becomes law, because it is so much easier. And people then just won't know the pain of trying to understand the Strata Titles Act before it was amended. Next slide. Oh, so you weren't here for the earlier session. So it was, all the amendments were brought in through Parliament late last year. They have been put into place, but they don't take effect until we get these regulations through, and it's the regulations that we're currently consulting on. So the other act that we got in at that time was the Community Titles Act. Look out for that. We'll be consulting on that, on the regs for that, hopefully early next year. So the Act will be proclaimed and the strata reforms will come into effect when we get these strata titles General Regulations 2019 in. So that's what we're really aiming to do at the moment. We're calling for feedback, so you coming here today is a wonderful way for us to realise that strata is of interest to people. When the regulations are completed, that's when the Act will go live. So when the regulations are proclaimed, then finally the amendments that we brought in late last year will actually take effect. So it's the Act and the regulations working together that bring in the new suite of strata reforms. So here we are in September. The public consultation period will close at the end of September. Then we'll be using October to take on board all of the feedback that we've received and, making changes where we need to. We aim to get the regulations to table them in Parliament in November. After that, how long it takes to actually come in is out of our hands, because that's subject to the parliamentary process. But we'd really be hoping for as little delay as possible, and hopefully it'll be the regulations 2019 instead of 2020. But yeah, that last bit is actually out of our hands. Okay. So here are all of the topics of reform, and for those of you who've been here since this morning, you've already heard quite a lot of these. This session is on bylaws and simplifying dispute resolution. Earlier this morning I spoke about improvements to scheme management, and if you missed that session there'll be a video up on our website hopefully by next week. I've also covered off earlier on better information for buyers and introducing safeguards for scheme terminations, and we'll have 2 sessions after this one: leasehold schemes and enabling more flexible stage subdivision. Bylaws. If you have anything to do with strata, you know how important bylaws are. What are bylaws? My colleague Glenda earlier said that a strata community was like its own little democracy, and the bylaws are the rules that everybody in the strata scheme must follow. Who must follow them? The strata company itself, which is comprised of all owners, all lot owners and all tenants who are there as well. And what a bylaw is, it's as if each of those parties had signed an agreement to do what is set out in the bylaws. So it's the rules of the entire strata scheme. Now, these are matters that were implied in the current Act that hasn't been amended, but in the strata reforms this is made explicit, that what a bylaw is. Okay, what challenges are there under the current Act in relation to bylaws? Well, a strata company can make, amend and repeal bylaws. However, sometimes they do that using the wrong standard of vote. And that can be really important. In the previous session, I was saying that you have some bylaws which are really, really important. They're the foundation of how the strata company is run. Schedule 1 bylaws, for example, that talk about how a council is constituted. It really has a big say on how the strata company is run and managed. And the resolution for a bylaw of that type is a resolution without dissent. That's a very high standard to meet. Conduct bylaws, Schedule 2 bylaws, that's a lower standard of resolution to change. It's generally about things like, drying of laundry or vehicles and parking. And the standard to change a bylaw of that nature is a special resolution, which is at least 50% in favour, less than 25% against. Now, if you've got strata companies who are actually making bylaws using the wrong voting standard, you could actually have some consequences of that aren't that good. So, for example, people could actually sort of easily introduce something that they shouldn't, which changes how the strata scheme itself is run. So that's undesirable. The current Act provides no guidance around when a bylaw is invalid. You can read the entire Act and it really doesn't say anything about what is a bylaw that is valid. And so this has been changed in the current Act. Now, the strata company has a duty to enforce bylaws. It's part of, that the scheme be run properly. Everyone must adhere to the bylaws, so the strata company has a duty to enforce bylaws, but unfortunately very little power to do so. So, under the current Act, enforcing a bylaw is really hard. A penalty cannot be imposed unless the bylaw specifically states that there is a penalty. Now, under the Strata Titles Act, Schedule 1 and Schedule 2 up the back, unless a strata scheme actually has its own unique set of bylaws, most schemes are running on those default bylaws. And those default bylaws don't mention a single penalty. So there the strata company is, and it has a duty to enforce bylaws, but absolutely no ability to actually impose a penalty. So, in addition to that, proving a breach of a bylaw is difficult, as it must be established that the person has willfully and persistently breached the bylaw. Willful and persistent is actually quite a high standard to reach. Somebody could breach a bylaw in a really deliberate way, but maybe do it twice. Is that enough to be persistent? Or perhaps they could persistently breach a bylaw forgetfully or, ignorantly. They didn't know any better, or they say they don't know any better. So, very, very hard for the strata company to enforce bylaws. So we've made some changes to bylaws as part of the reforms. Currently, Schedule 1 bylaws will now be called Schedule 1 governance bylaws. They need a resolution without dissent to create, amend or repeal. Schedule 2 bylaws are now also called conduct bylaws. To create, amend or repeal these takes a special resolution. So from now on, or when these reforms come into place, if a strata company makes, amends or repeals a bylaw, they must indicate whether it's a governance or conduct bylaw. And by doing that, it ensures, hopefully, that they have the correct voting protocol for a bylaw of that level of importance. So, you don't get, hopefully, the consequence of, them changing the way the strata company is run and managed with the wrong standard of vote. Okay, as part of the strata reforms, we've moved some of the bylaws around. Some bylaws have been deleted. For example, we deleted a bylaw saying that children must not play on the common property unless supervised by an adult. Some bylaws have been put into the Act instead. So, for example, there were bylaws establishing people's ability to vote and their voting rights. It's a really important factor of people and their ability to control and have a say in the running of their scheme. Because it was in a bylaw, that meant that it could actually be changed by the strata company. That was undesirable, so we've actually changed those and put them into the Act themselves, so nobody can actually take somebody's voting rights away from them. We moved around a bylaw about decorating from Schedule 1, which it wasn't really a Schedule 1 sort of governance bylaw matter. That's been put into the conduct bylaws. Due to all of these amendments, and we've moved things around, it's now possible that a strata company will have a bylaw in the wrong schedule. Don't worry, that bylaw is still enforceable. The only real impact is considering what level of vote is required to change, amend or repeal that bylaw. So if what we're requiring is if the strata company makes a new bylaw, or amends or repeals one, they should review their bylaws and lodge a consolidated set. And we'll have some information up on our website explaining what movements we made, what we've moved and deleted, so that's to guide strata companies so they can more easily change their bylaws to reflect the changes that we've made in the Act. So, as I mentioned, the old Act doesn't have any information about when bylaws are invalid, but the new Act actually explicitly states that any bylaws that are made must be valid, and they're invalid if there was no power to make them. What does that mean? Well, like I was saying, the bylaws actually are like an agreement of between the people resident on the strata scheme to abide by those rules. And for example, you could try making a bylaw to control your neighbour who doesn't live in the strata scheme. Well, you're out of luck because there's no power to bind that person. They're not a resident of the strata scheme. Bylaws are invalid if they're inconsistent with the Act or any other law. So I had a question during lunchtime. Somebody asked about, well, can you make a bylaw to allow or to ban Airbnb? Well, one of the things you have to consider is what are the local laws in relation to short stay accommodation. So you can't put in a bylaw that you can allow Airbnb if actually the local laws forbid that sort of accommodation. So you have to, when making a bylaw, it has to be consistent with any other written law. Bylaws are invalid if they limit the right of an owner to vote on a resolution. And this is, like I was saying before, that's why we moved the bylaws about voting into the Act. You note that exception there, that the Act might set out exceptions to limiting the right of owners to vote. That's in particular in relation to there are some restrictions that an owner can't vote on something if they're not financial, for example, if they haven't paid their levies. And that is very clearly something to encourage people to pay their levies. Bylaws are invalid if they prohibit or restrict someone from selling their lot. As you can imagine, it's a really important thing that makes an asset valuable, that you can actually sell it or deal with it as you wish. Bylaws are invalid if they prohibit the use of an assistance animal. Somebody was asking about this earlier. Your assistance animal does have to be a registered assistance animal. You can't bring along your parrot and say it's an assistance parrot. I forget the federal law that talks about registering assistance animals, but I think it's the Discrimination Act. Sorry, I don't have that in my notes. Anyway, so a bylaw is also invalid if it's unfair, discriminatory, oppressive or unreasonable. And that's a really important factor to consider when we go into dispute resolution. There's a couple of other things that make bylaws invalid, which are a little bit more specific. You can't change a restricted use condition imposed by planning or local government. If it's a leasehold scheme, you can't make bylaws that are inconsistent with a strata lease, and you can't make a bylaw that discharges an easement. So in summary, for bylaws, we've provided a lot more clarification and guidance around the nature of bylaws and the type of vote that must be achieved to change them. The strata reforms provide that bylaws must not be unfair, discriminatory, oppressive or unreasonable. And these criteria will be very important if a dispute arises, which brings us on to dispute resolution. Sorry? One? Oh, sorry. Can I stand in front of it? Okay. Right. So one of the challenges under the current Strata Titles Act is it provides throughout the Act for various different things. There are different forums you can take your dispute to. So currently there's 4 different forums. There's the District Court, Magistrates Court, Supreme Court or the State Administrative Tribunal or SAT. The dispute resolution provisions are complex. They're too specific and they limit the power SAT has to resolve strata disputes. What do I mean by too specific? And it's one of my real headaches reading the current Strata Titles Act. It doesn't provide broad general principles. It tries to provide a section for every single thing that might arise. And so if you look at the section around orders SAT may make, there's a really long shopping list of orders SAT may make. And one of the things I've learnt in these strata reforms is you can tell where the trouble spots are in legislation, because where amendments have been made over time, Parliamentary Counsel's Office, they don't renumber everything. They want to keep all the important section numbers so people can say, oh yes, that's section 33. So you can see where the trouble spots are. Between one section and the next section, there'll be all of these subsections added. Maybe with an alphabetical number. So when it comes to the section about orders SAT may make, you have section 103 and 104, and in between 103A, 103B. Well, I won't go on, it goes on to 103R. And despite all of these additional orders that SAT may make that have been added over time, there are still gaps, because when you're that specific, things fall through the gaps. And so this has really limited SAT's powers to resolve strata disputes. Okay, but we're looking to simplify dispute resolution. So under the reforms, disputes will be resolved efficiently and at less cost, with SAT becoming the one-stop shop for strata disputes. Why did we do this? Well, SAT is an independent tribunal. It's less formal and has more flexible procedures than those used in traditional courts. And it provides a more appropriate and quick way for people to get disputes resolved. And really, if you've got a dispute about a parking bay or maybe somebody drying their laundry on the balcony, do you really want to go to court about that? So what will be changing? SAT will provide parties with access to a cost-effective dispute resolution forum and be given broader powers to resolve scheme disputes and empowered to more easily enforce bylaws. Just note that if there are any unpaid levies in the scheme, that's a matter that will still be taken to civil courts. What will be changing? Okay, so the amended Act clearly sets out that SAT may resolve disputes between scheme participants. Okay, so what's a scheme dispute? It includes any matter arising under the Act, including in relation to bylaws, resolutions, the election of office holders of the council or the strata company. Who are scheme participants? Well, these include the strata company, lot owners, tenants, registered mortgagees, that is banks, council members. It also includes the owner of a leasehold scheme, if it's a leasehold scheme, and an administrator, if one has been appointed. So, the Act gives SAT broad powers to make declarations. What's a declaration? Well, for example, SAT can make a declaration that somebody has contravened the Act or a bylaw, or in fact has not contravened the Act or a bylaw. SAT may make a declaration that a bylaw or resolution is or is not invalid, or that the appointment or election of a council member is or is not invalid. This is a power only exercisable by legally qualified members or by the tribunal constituted of a legally qualified member and other members. Now, SAT may have broad powers to make orders. I spoke a little about orders earlier. In comparison to the long shopping list that the Strata Titles Act had before, the amended Act provides, in a proceeding under this Act, the tribunal may make any order it considers appropriate to resolve the dispute or proceeding. In all fairness, it then goes into a long list of specific orders that SAT may make, but it really puts beyond all doubt that SAT has the powers to deal with matters arising under the Strata Titles Act. So, no more matters falling between the gaps. Okay, enforcing bylaws. The strata company, owners and occupiers can apply to SAT for an order to enforce a bylaw. And the SAT will have the power to make an order that a person stop breaching any bylaw or fix the breach of the bylaw. So here's something that's new, enforcement of an order to act. So if SAT, let's say, has made an order that a person take a particular action, maybe repairing any common property that they've damaged, and the person doesn't do that action, SAT may make an order for them to pay money to compensate for their failure to act. So, for example, that could be to pay for a builder or some other party to fix the damaged common property. That's a new power, and I think that will be quite useful to have. SAT can order a person breaching a bylaw to pay a penalty in any of the following circumstances. The strata company serves notice and the breach continues. So this is where the person can't argue ignorance because, they were given a notice by the strata company saying, please cease and desist this activity. Or the breach is serious, so that could be, just on one occasion somebody damaged the common property and it was really serious, so a penalty could be payable there. Or the breach occurs 3 times, and this is where we've sought to actually define what persistent actually is. But it's not all 3 of those together, it's any one of those 3 means that a bylaw can be enforced with a penalty. Okay, SAT's powers have been broadened. So these are just some examples. SAT will have the power to resolve disputes between lot owners about bylaws, resolutions, the appointment or election of council members, between a buyer and seller of a strata lot about the information which should have been given before the contract was signed, between a strata manager and the strata company about a strata management contract. And that's just a small number of examples of the disputes that can be heard by SAT. So in relation to amending and repealing bylaws, SAT will have the power to amend or repeal a bylaw on the basis that it's oppressive or unreasonable, unfairly prejudicial or discriminatory against one or more owners. What's a discriminatory bylaw? Well, for example, I mentioned that we deleted the bylaw that said that you couldn't have children playing on common property unless they were supervised by an adult. That would seem to be fairly discriminatory against the parents and the families that might actually choose to live in the strata scheme. So, effectively resolving strata disputes. There was a limit on SAT monetary orders of $1,000. That's been removed. SAT will also be able to award costs in strata disputes. So if you have somebody who has damaged the strata common property, as I mentioned, you know, if they are actually subject to having to pay costs, that might be a good incentive to not damage the strata property. SAT will also resolve disputes between the strata company and strata manager. Resolving strata disputes quickly. SAT will be able to make a final decision in proceedings at a directions hearing if it considers that appropriate. And owners can go straight to SAT without having to go through other more expensive procedures. And what that's in relation to, the old Act, before it was amended, actually had a bit in there that said, well, first, if your bylaws say that you must go through some other dispute resolution process, such as mediation, you have to do that first before you go to SAT. That section's been removed. One of the things we found, for example, is that mediation can actually be quite expensive. So we heard figures around the $700, $800 mark. It's actually cheaper to go to SAT. So in summary, dispute resolution. As part of the strata reforms, we've made extensive changes to help people living in strata to deal with disputes as they arise. Most of these changes relate to broadening the powers of the State Administrative Tribunal to deal with disputes that do arise. Now, as I mentioned to start with, we're consulting at the moment. We'd really like your feedback, and this is your opportunity to have your say in how things are done. The regulations are downloadable from our website on strata.wa.gov.au. Please go and have a look. I know there's been a lot of work done on them. And if you would like any more information, all of these sessions held here today are going to be recorded. They should be up on our website in the next week. Or you could also subscribe for updates on the key developments as they go ahead. And I must have this disclaimer, I'm not actually a lawyer. I've advised you as best I can, but before you do anything based on my advice, I really strongly suggest you read the Act and the regs or take legal advice.